Good day. This is Practice Ready Evidence, and we're talking in this particular series of presentations about the connection between the federal rules of evidence and the federal rules of civil procedure as they impact the testimony of expert witnesses and the testimony of witnesses who are designated to testify on behalf of a corporation or entity and bind them by nature of the federal rules of civil procedure. And the thing that I want to deal with today are that connection between expert witnesses, witnesses for the corporation, and 30B6 witnesses. And for those of you who are interested in evidentiary law, this is going to be slightly painful for you because I'm actually going to talk about the federal rules of civil procedure. Why? Because they have a huge impact on how we present a witness, on how we go through the discovery process in the pretrial phase of litigation. And I want to begin by looking at the law of Federal Rule of Civil Procedure 30B6. 30B6 witnesses are unique witnesses. I like to think of a 30B6 witness as someone that I look for when I don't know what I don't know. When I am trying to discover information that I have a right to know based upon the cause of action that I'm engaged in, but I don't understand the structure of the company, the players involved within the entity in a way that would allow me to notice a deposition of a particular individual under 30B1 of the Federal Rules of Civil Procedure. And this vehicle resides within the Rules of Civil Procedure to help us in that regard. So what is a 30B6 witness? A 30B6 witness is a witness that is designated not by the party seeking to depose, but by the party being deposed. And what happens is a notice is given to the party to be deposed, describing with reasonable particularity the subject matters that you wish to address in the deposition, and requesting that the corporation select a person or persons who will speak on the behalf regarding those subject matters. And there's a really cool thing about 30B6 witnesses. I could have one 30B6 witness, and it might take the corporation 6 people to answer that question, that subject matter that I've inquired on. Those 6 people only count as one deposition for purposes of my limitations of depositions. So 30B6 witnesses can be extremely helpful to us as attorneys, but they're problematic to us. And they're problematic to us because, quite frankly, if we don't give proper notice under the rule, we may get someone who can't answer the questions that we really need to be answered. And if we don't give proper notice, we may lose the ability to go forward to the judge and to get relief so that we can get another witness. So this 30B6 process really needs to work properly from the beginning. It needs to work well from the moment that the notice is drafted with particularity so that we can find out the information that we need. For example, let's say that I'm looking for a 30B6 witness that I want to put together for purposes of learning about the communication structure of an entity. I'm trying to sort out who talks to who, what are the hierarchies of people, who reports in which fashion, who has what email address, where's the information stored, what servers do they have, are the servers on-site, are the servers off-site, are we dealing with a cloud situation? I need to get into the intricacies of electronic communication or electronically stored media, electronically stored information for this particular company. And I may be doing this in the deposition process so that I can prepare myself, posit myself for a subsequent ESI discovery battle. But I don't know how it works in that particular organization. In that example, a 30B6 witness is a great way to acquire information to identify structure. So that's one place where a 30B6 witness can be very, very helpful to us. Of course, sometimes that may potentially run into a trade secret issue, and you've got to be aware of that as well. Let's take a look at this next slide. They always raise an important issue because the cool thing about a 30B6 witness from the standpoint of the person who's deposing is that it's going to bind the corporation. An individual speaking in an individual capacity may or may not bind the corporation, kind of depending upon, quite frankly, whether or not they're an officer of the entity that has the authority to bind. But a 30B6 witness, by the very nature of their selection as a 30B6 witness, has the power to bind the corporation. And what's interesting is that sometimes I can have a witness, a portion of their testimony could be 30B6 related, a portion of it could not be 30B6 related. Or I could have a witness who is a regular 30B1, just fact witness that I'm deposing, who also by nature of their status within the organization may be able to bind. So all of these thought processes have to go into the selection of the 30B6 witness on the part of the party that's being deposed, and they go into the thought process of the party requesting the deposition. The way I draft that notice, the particularity that I use is really going to matter because it's got to connect to. There must be an interweaving with the other depositions that I intend to conduct. And so there's a natural witness analysis that goes to it, and then there's this is going to be an admission, this is going to be a binding analysis, and I have to think about both and the way in which they connect as I go forward. And the other good thing about 30B6 witnesses is that they'll actually help us identify other witnesses within the trial. And so there are two ways that lawyers have historically used 30B6 witnesses. One is as the wrap-up witness, the last nail in the coffin. I'll take the 30B6 deposition when I've sorted everything out and I want to make it perfect. And then the other way to do it is I'm going to take that 30B6 witness to discover what I don't know so that I can fully develop my case. I want you to have the idea that both are appropriate, both are effective, and in either set of circumstances, the scope is going to be the ruling issue, right? Because if I look at the scope of the notice and I look at the issues that I rely upon for designation, it's going to define the reasonable areas of inquiry, and it's going to define where 30B6 is going to apply and bind the corporation. And this is important to me because I would suggest to you that you go and look at the other presentations that are available on depositions, particularly paying attention to the funnel questioning technique, because the funnel questioning technique is going to lay on top of the scope of my inquiry of the 30B6 witness. So how I define it from a particularity perspective is going to determine the degree to which I'm going to be able to bind this corporation prior to trial. So I want you to go back and look at the other presentations that are available, whether on my YouTube channel or in other media, depending upon where you're viewing this. And I want you to bring together your understanding of the rules of evidence as they apply, the Federal Rules of Civil Procedure for 30B6 witnesses, with an overlay of the proper questioning techniques at deposition. 30B6 witnesses are not experts, although they often have expertise and could potentially be qualified as an expert as well. But we're going to leave that particular presentation to whenever I see you in person. Till next time, I'm Charlie Rose, and this has been Practice Ready Evidence.